questions, and so we will get started with Superior Court. So, Judge.
Thank you. Good morning. Tim Fennessy, for those of you that I haven't met. And I am the presiding judge this year. We are here to address your request of us and to try to explain our rationale. I'm going to turn the first part of the presentation over to our court administrator, and then I will look back in and address what we see as our continuing needs and the reasons behind our request, and then try to help explain what our request is over a further plan in the future. Thank you.
Morning. Thank you all for letting us come and chat about the courts with you this morning. The first slide explains what our first request was. We heard Scott as he told us back in May and June that 2025 did not look great. And so we really went through line by line and came up with what we thought were realistic expenses for the court next year. And then we were told a few months ago that nope, we needed to cut more. We needed to get back down to 2024 amounts. And so we went back through the lines and shaved off as much as we could realistically expect that it will cost the court to run in 2025. We shaved 115,000, which did not meet the total requested amount. But we are respectfully requesting that the VOCC approve what we now have submitted as our 2025 budget. We can go into, and go ahead and stop me at any time if you have questions. We can go to the next slide. So really the court breaks down our expenses into three groups. One, of course, people costs. Those costs are outside of our control as far as what the wages are and the benefits. And then where we really have control is our discretionary expenses, which, as you can see, just amount to 3.5% of our total budget. We are extremely lean, and we take a lot of pride in that. Ms. Leanne Wakefield, our assistant court administrator, is here. Every department should have a Leanne. She does a fantastic job trying to shop around, find the least expensive things that we can buy that are still good use of taxpayer funds. And so we do take a lot of pride in the fact that we are extremely lean. Our non-discretionary expenses are about 6.5%. And those include jury fees, attorney appointments that we are required to appoint, interpreters, which we know has been discussed a lot. You'll notice in 2022, our non-discretionary expenses dipped way down. Historically, they've been at about 550,000. That 2022 dip was because that's when we began receiving state reimbursement for some of our required costs. I've come down and asked the VOCC to approve the contracts with the state. And because of the way that the lines were set up, the reimbursement went back into that line, which made it appear as though we didn't spend the funds, but we did. It was just then reimbursed by the state. So even though it looks low, that is not a realistic amount for what it cost the court to run in 2022. Go to the next slide. As I mentioned, most of our M&O is required. Jury fees, we have 100 jurors that are going to be here today for trials that are going out this week. They get fantastic $10 a day plus their mileage. So it works out to about $20 a day per juror. We like to see jury trials. We like to get cases that need to go to trial. We are very lean as much as we can. We do need to make sure that the juror addresses are correct. We don't want a bunch of returned mail. But as we went back and tried to shave as much as we could for 2025, we did reduce that amount by 7%. We, based on the trends, believe that is somewhat doable. But the truth is that if we have a lot of jury trials go out in 2025, that's fantastic. And we'll be back down here to say, hey, board, we really tried to cut, but we're seeing a trend upwards, and we're gonna need a little bit more for 2025. The GAL appointments, we went down 5%. And we are seeing interpreters, the Spokane community continues to be more diverse, and we're going to see those expenses go up each year if I were to bet on it. But we do receive some reimbursement from the state, and we will continue to seek ways to fund that required line. In the indigent defense, again, there's a very small or a narrow area where the court pays for some fees on that. We have no idea when those expenses are going to come our way. It just depends on the types of cases that are filed. We do require them to seek court, the court has to approve the expenses, so we try to keep a very close eye on those as to not let people spend too much that they don't need. Our arbitration also, we went down a little bit for 2025. This is again, just to look at trends. Our arbitration is great when it works because it does resolve a case. We are required to pay for it. The state does pay half of it. So this is just a rundown of our required expenses that take up a large chunk of our M&O. We can go to the next slide. People costs. People are expensive. The court has not grown aside from the 13th department, which we are still very grateful of that the board approved. But as far as positions, we have not grown over the last 5-6 years. There are a few positions that we have gotten through a grant from the state. But for the most part, 90% of our funding is people. 4 of our court commissioners are paid for by the BOCC. 4-ish, little less than 4, I guess, are paid for by either reimbursement from the state for child support cases, or through grants or the ITA expenses. And I would love to say that, you know, we've looked at this and can think that we think we can get by with less people, but we just can't. Our workload is increasing. We have such a broad amount of case types that we need to be able to move through the courts. We do have 2 court reporter positions that are unfilled. We have been recruiting for these positions for 1.5 years, 2 years. There's just shortages across the state in that very unique field. I'm not sure if we'll be able to fill them, but the truth is, having a court reporter ensures that when a case is appealed, record is complete. And we need to be able, when we receive an app from a court reporter that is qualified to serve in our court, we need to be able to hire them because, again, courts across the state competing for the exact same people with a very unique set of skills. Next slide. This is my last one, and we're really proud of this. One of the ways that you gauge court performance is, does the court complete as many cases that are filed? And so I broke it down by each case type. There are 8 case types. So I think it's important for the board to recall that we do a lot of a variety of case types. And where we see that we don't complete as many as were filed, then we try to see if there's, any blockages that are not allowing that case to move through the courts to resolve. When you look at 2024, year to date, we have completed almost 600 more than were filed. With that 13th department, I think that we're going to we'll see this continue to work. I mean, we've tried to find ways to make sure that we are being as effective and efficient as we can. And I think that this chart shows that we have done a pretty good job so far this year, and I hope that it continues.
So Ashley, on that, a couple questions I have. See Matt Anderson in the corner there. That, so we see some are below and some are higher. So these are just the filings for this year, but we had a backlog
Yes.
on some of these, correct?
Correct.
And so how are we doing on that backlog?
Better, much better. Having that
Sorry,
trial,
on the
well,
spot.
no, it's fine. Having the ability to send a case to trial gets rid of the backlog by itself. When we have talked about criminal cases, what is impacting the courts is the lack of staff. Larry, Colin, C. It's hard, and the judge can address this better than I, but as we try to move things through, if an attorney just got a case, you can't force them to go to trial. And if they just met their client, even though the case has been around for 5 months, it takes time. So we are seeing an improvement. Is it where we'd like to be? Not yet.
Okay, and then on the civil side, because that seems to be the one still.
Yes, definitely still a gap. And we're trying. We had civil cases, a 10-day jury trial go out last month, which is fantastic. It's not even just the case. A lot of times they're very complex, and it takes weeks of a judge's time to resolve it. And it's hard to find a judge that has 2 or 3 weeks. So we were thrilled to get a 10-day jury trial case out. That's huge.
I think historically speaking, across all case types and across as much time as I can think of, well over 96% of cases settle. And the way to get cases to settle is to tell them that they have a trial date. And once we give them that and we can provide that and follow through on that, then they often resolve cases, which is, again, one of the things that the bench has done historically to address making sure that each of our trial courts has 2 or 3 or 4, and sometimes in the family law cases, 8 or 10 or 12 matters set to begin each Monday. So that if those cases ahead or if those cases resolve, that we still have, or that we then have other cases on the backside, so that that department can stay busy. And it's very rare that a judge sits open for an entire week. Our judges have done a remarkable job of managing that. And that is one of the things that, in terms of the domestic filings for this year, we have completed less than we took in. But as a bench, in our evaluation of what to do with the 13th department, we opened a 3rd family law docket that just started being fully functional last month. And say August, so it was last month. And we expect, and we have historic data that shows during the COVID pandemic, we were able to dedicate a trial judge, because we weren't able to have jury trials, to the family law department, and that was Judge Cooney, and we saw a dramatic decrease in that backlog during that year 21. So we expect that.
Thank you.
Well, that was gonna be my question. I know you were evaluating which of the case types, you were gonna have the 13th judge take on, so is this new family law docket like the largest change that
Yep.
you've made? Okay.
And I will say, just to explain through that a little bit more, so a judge hears the case when it goes to trial. Commissioners hear all of the temporary orders. So if we can't resolve a case within 6 months, we'll say the workload of our commissioners continues. And so we thought, well, to get the most bang for our buck, getting domestic trials completed within that 6-month range is really going to not, it'll reduce the backlog, also will reduce the workload of the commissioners. So it really seemed like it would make, and again, that's not to say that if there was a jury trial that needs to get out, domestic judges can take those too. I mean, it just trying to get those trials resolved so people can move on with their lives seemed like a really good use of that resource. Turn it to the judge.
So just as a recap on a couple of things, we were able to make adjustments and reduce the areas as Callan explained. I just want to highlight that we do anticipate, if we're successful, we will have a lot of jury trials go out. And the backlog in the criminal side of things has been created because both the Office of the Public Defender and the Office of the Prosecuting Attorney have been understaffed. And as the Chief Criminal Judge, I'm having an awful lot of conversations with lawyers saying, I'm just taking this case over. We're trying a new case management style. I think previously it was felt that replacement of counsel on either side would sort of reset the entire case. And what we've been working on and trying to communicate with the lawyers is that we can have expectations every 30 or 60 days. And that once that lawyer gets past that first day, that first 30-day or 60-day deadline, then if they are replaced, we don't have to go all the way back to the beginning. We can just go back to that 60-day. Now, the new lawyer is still going to need some time to catch up on that file, but the work should have been done. The discovery, the interviews, the preparation, those things ought to have been done. It shouldn't have to take the full 60-day period. Maybe they'll take 15 days or 20 days to catch up. So as we have those conversations with the lawyers, they are better about passing off their files and making sure that that happens. But that's not controllable either, because sometimes lawyers just pull up and say, I'm done. I'm not going to work with that format. But so I just want to kind of highlight that we've decreased that, but we believe that we may be back here asking for supplementals because that's a necessary expense. And interpreter appointments, as well as indigent defense, we know that we're going to have an increase in needs in those areas if we're doing the best that we can to manage that. I just want to highlight that those are areas that we have addressed as completely and as well as we can. And with regard to this, the superior case types, as Ms. Callan mentioned, we are very proud of the bottom line. And we recognize that in certain areas, the domestic area, I've advised how we believe that will be addressed. The probate guardianship, that number is somewhat alarming, but we think that it's probably ameliorated by the fact that sometimes you have probates and guardianships that just go on for years, and it doesn't take a great deal of court administrative time. It doesn't take a great deal of court time. It's just that they will be there for a long period of time. And so closing those out, completing those cases isn't as important. We're only reviewing and making sure that the private counsel or outside lawyer is doing their job, or the guardian is doing their job, kind of having minimal oversight. So then the area that we are somewhat concerned about is the civil. And we are focus on every way that we can, and we'll address that some when I come back to our plan in terms of our ask for you. I also want to take a moment to explain some of the issues that we have in terms of why we think that our people are central to our mission. People are so important. And that's perception of justice and fairness in our community. And how, as much as we are trying to be lean and proactive, we have some things that we just have to take care of, and that they take additional time. Recent legislative impacts, as we all know, with COVID and with the moratorium on evictions, we created quite a backlog. And this chart shows that year to date, we have 2,747 cases, unlawful detainer cases filed. If that were to work out and go forward mathematically, we would end up with over 3,600 cases, eviction cases. And in each of those cases, the tenant now has a right to counsel, which creates more lead time for the landlord, makes it somewhat more difficult for the landlord, and makes the process, if there is a hearing requested, much more time consuming for the judicial officer. If only 10% of those cases, that 3,600 required hearings, and each of those averaged 4 hours, that would be 183 days judicial time that is necessary as a result of the legislation.
So now, tenants are, who's the attorneys that's representing them then if they have a right to counsel?
Locally, they have the Northwest Justice Project, is one of the funded providers of that service. And then I think it's a Seattle Housing Project as well that has counsel here in Spokane. Those are paid for as long as funds are available through the state. So that is not an expense to the county, but it is an expense to us in terms of the time required that they have a right. And landlords are mostly represented by a few law firms that have studied this legislation, participated in writing legislation, and are very understanding about that process. And they're doing everything that they can to limit their clients' exposure, but they still they end up in proceedings. There's a right to what's called essentially a summary judgment proceeding up front, and then a jury trial hearing if they request it and go forward with that. And so it can be very, very time consuming for the county in terms of judicial time.
Thank
you. We're continuing to explore whether or not we can have some of our district court judges address those. We have talked with the AOC, we have talked with other county benches, and we're continuing to explore whether there's an option of having our 1 or 2 or 3 of our district court judges appointed as what we call AR6 judges. That won't occur again in Spokane County until April. And by then we'll have a better view of whether or not we can actually have those cases assigned to those AR6 judges, and whether or not we have 1 or 2 or 3 district court judges who are willing and able to take on that extra. But we continue to work to do as much as we can in that regard. Thus far, as we can tell, because it's a possessory interest to real property, it's required to be heard in the Superior Court. That's what the jurisdiction is. That's
Next slide.
The next slide, pardon me.
So you move
Yeah.
on. So I am one of those landlords, and you know, the attorney, when we had to deal with an eviction, said, you know what, it's going to be easier and faster just to go to the tenant, give them a cash payment, get them out, and be done with it, as opposed to going through court. And as I talk to more and more landlords, they're defaulting to that as a solution, as opposed to trying to go through the system and stuff. So that's reality out there. In terms of not having to try and go through the court. The question, on custody, how long does it take from when a custody complaint is filed until they see a court date? And do you require mediation prior to court or not?
The rules require mediation prior to court,
Okay.
and then it's up to the parties to indicate that they refuse to go. Sometimes parties indicate that they are refusing to go and that there's no purpose in the mediation, and so we force mediation.
So how long until they actually get a court date? How far behind are you with regard to getting a court date for custody hearings?
I don't have a specific timeline for you. I can't say, and I think it's very extraordinarily variable. It depends on, do you have self-represented litigants in that custody battle? Is one side represented and the other side not represented, or are there
Okay,
two attorneys involved? All of those things will dramatically impact the ability to get to a court. I would say it's probably 6 months from filing to get a actual court hearing before a superior court judge. It's not likely long, it's probably shorter than that, 3 months to get a hearing before a commissioner. But that hearing is going to be on preliminary matters and not on the part of the.
yeah, so if you hold the hearing, the hearing will be held, but then you're gonna set a court date if they choose to go to court. So there's another time period in there
Yes.
and stuff. So I just, got a friend that's in the Ada County going through this process, and they went through the hearing, didn't do mediation. Well, they did mediation, but it wasn't successful. And so now the court case is, it was just decided last week, and their court case is in February. So I was trying to get some kind of relationship between, if that's how far it is down there, how far are we behind up here in terms of getting into the court and actually getting some kind of resolution. So, yeah.
And that would not be out of line for where we are. We hope that we're getting better with the third department. And we do know that recently we've had a change as well in the statutes to allow for parties to choose what we call informal divorce proceedings. And so if they choose that path, it's much quicker, and they don't have lawyers. They just present their issues to the court without the rules of evidence.
Thank you.
And I can't address what other landlords are doing. All I can say is where we are presently is that we have had an explosion of eviction filings. And even if 50% of the landlords, I think, chose that path to cash pay and rather than bring it to the court, we'd still have more than we are used to.
Yeah.
And still, all of those hearings that we have are dramatically longer than it used to be. That docket used to be folded into our plea broker and unassigned civil motions. And having sat on that docket, we would, maybe have 8 cases set in a week, and only 3 of them show up. And 2 of those would resolve in the hallway before they ever were called.
Right.
And then maybe once a month, we would actually need hearing time with a judge outside of that department. And that's just not the case.
Thank you.
Thank you. RCW 7-105 addresses domestic violence protection orders, sexual assault protection orders, stalking protection orders, and anti-harassment protection orders, as well as vulnerable adult and extreme risk. And all of those were folded into this statute with new deadlines for effective dates of March in 2022, July 2022, again in July of 2023, and there's one last additional change will become effective July of 2025. And those all are, it's essentially, we used to have different forms and different slots for those cases to fall into. And the legislative change said, we want to avoid delay in these types of cases. We want everything to be heard and addressed. And so once in the hopper, they all come to Superior Court and they all require judicial time, which is different and is a big complication as we sort all of those things out and address each of the changes going forward. We also have had resentencing requirements with regard to, we have what we call US Supreme Court. It had a case by the name of Miller, and Washington State Supreme Court has a case called Monchke. Both of those require the courts to consider youthfulness as a mitigating circumstance. And so we're having to have resentencing in, I think it's now about 150 cases was what we anticipated across the state. And those are very timely. Obviously, we've got to bring the accused back from wherever they are being housed. We have to oftentimes reinform a new judicial officer and have those hearings, and it's time consuming and it's difficult. So that's, again, one of the recent changes that we're seeing take up more of our court time. Additionally, the legislature changed and indicated that robbery of the second is no longer a strike offense. There were 277 people incarcerated in Washington State in regard to third strike cases, where that now has to be reconsidered as well. And then we do have new compliance review hearings with DNA submission. There's no longer a charge for that, but we have to schedule it. We have to make sure that they donate the biological sample within 7 days, and then we review that, make sure it gets done in 10 days. So we do have, and then firearm surrender, we're required scheduled compliance there as well. So we have additional demands on our time that are taking up any of the efficiencies that we're trying to find in other dockets. So then we come to our plan and our ask of each of you. We have 19 courtrooms and 21.
Next
Oh,
one.
pardon.
Search warrants.
Oh, yes, we have the search warrant requirement. Every day we have email chains that go out, at least 5 to 10 and as many as 15 warrant requirements, and that is our warrant requests. Those are being passed out to each one of the members of the bench. And so we're all shouldering that load, and that's an increase in terms of time, and it's requiring people to take time away from either prep time or decisional time or whatever other chambers time they might have planned. And then over the weekend, we have to be available to review warrants as well as to address custody, bond, and or probable cause decisions in those individuals who are arrested on Friday night through Sunday morning. And so we serve as judicial officers 2 or 3 weeks per year, depending on that rotation. So that also has impacted our workload. And I was in yesterday to try to make sure that we were ready for this today. And our on-call judge was having difficulty with his connection, so he was not able to sign the search warrants electronically, and that causes obviously a complication. He had to stand out on Cheney, and when those things happen, we have to fall back. Sometimes we don't have judges that remember that the officer can actually come to your house if it's absolutely necessary, and we can sign it by paper. But those are the things that are also taking on additional time for all of us. Next slide. Then we're at what is our future plan and what do we hope to have accomplished. We believe that we presently have 19 courtrooms and 21 judicial officers. And we believe that all of our judicial officers need a functioning space. Our 13th Superior Court judge needs a functioning space where trials could be held. And we appreciate the hearing room, and it has been put to good use. We have first appearances there, and that is being useful and being utilized. But we really hope that we can ask you for more space, even if it's on a temporary basis. I think that we have established that we're willing to do what it takes. If we have to find a different space, we went out to the fairgrounds to try cases. And we will do what we need to, but we do need a space that is functional. And we hope that that would be on a temporary basis, and our ask is for you to plan and help us provide any information that you have or that you need so that we can make a plan for additional judicial departments in terms of courtroom space. We also believe that in the future, we believe today, but we certainly know that in the future, we will need 14th, 15th, and 16th judicial department. And so we're asking for you to help us agree to get the legislature to approve that funding now, so that when this board can fund it, it's in place from the state's perspective. And then we need, and I think that we have been before you previously asking for an IT person, and I think we're here with a better understanding to call that position a business analyst. We're not asking for someone that can write code or come in and change things the way that we do them, but to come in and analyze what we have in terms of systems and how those systems can communicate with one another. And then we can go to the county IT department and advise them of our needs, and hopefully we can get those IT fixes within the IT department as suggested by the business analyst, so that programs are talking to each other and we can search.
So with that one, is there a way to contract to have somebody come in and really do that, analyze that, and then be able to, you know, not have to have a future FT in the future? Because as we know, our budget is not increasing, you know, at the rate that everything else is. And so is that something that would be like, we can do as a potential contractor, really get someone in there to see what needs to be done and how to, because I mean, I was up with Judge McKay and saw all the different things that some are homegrown, some are not, you know, that are trying to all feed together. So it's like, you know, trying to figure out, yeah, what's the best way to do it. But I think, you know, for all of us, adding an FTE at this point is that long-term cost that I don't know that we can all continue, especially if you want to get future judges, which means a lot more FTEs, you know, with each judge. So
And excellent question. Obviously, what I would say is that I don't see how a contract person can come in, find out what we're using, and then plan a fix and then exit, because by that time, we'll likely have additional changes in legislation, additional changes in the state's software, additional changes in our own locations and business flow. So I believe that it's going to be something that we will need on a longer term basis than just a contract individual.
I agree. I mean, each time, we all know the softwares they need to be updated and upgraded. And each time IT does that, our stuff breaks. And it's really time consuming to figure out why things don't work and then be able to explain it to IT in a way that makes sense to them. And so I've talked to Kevin about our needs, and this is what he had thought would be more realistic for the court. As the judge said, our search warrant app broke over the weekend. I don't know. I'm not an IT person. I have no idea what went wrong enough to be able to explain it to IT so that they can fix it. It's just, it's a lot of, we have found a lot of ways to be more efficient using technology, but when it breaks, it's very hard to explain to IT what went wrong and make sure that it works again.
thank you.
Other,
Are there any questions?
The caseload analysis numbers, glad to see that there's more resolving than coming in. Is that a number that you tracked over time and is an improvement, or how would you kind of characterize that relative to recent history? If you know the answer, just curious.
We do track it monthly. It comes from the state databases. I didn't bring my historical numbers, but I certainly could send that to the board if they're like to see.
and I think that my belief is that it's an improvement in some areas and it's a holding in some areas, and that overall case filings peaked in maybe 2012, 2013, and then we had a dip, and that we're now back in the climbing phase, and that we're gonna see additional cases filed. And some of that has to do with, I think, being able to resolve cases in lower courts as opposed to filing in superior court, both for jurisdictional limits in civil cases, but also for purposes of the prosecuting attorney's office filing. When they
I was also gonna ask just about the current vacancies. You have the 2 court reporters, you said,
Correct.
and then therapeutic court coordinator, correct?
Hired one.
Oh,
She
very
starts
good.
next week
Is
on
that,
14th.
is that a general funded position, or is it grants coming?
It's through the 1/10 of 1% mental health sales tax.
Okay. Okay, therapeutic court coordinator. And then is there another vacancy?
I do have a staff assistant position that we is in my court facilitator's office, extending an offer to her today.
Okay, very good. Thank you.
So getting back to the first slide when you talked about, looking for reductions. So you provided a 580,000 and then you went and found another. So quick math, so it's 695,000 total.
They asked us to cut by the 580. That would
Okay.
get us down to the 2024 level, and we only were able to find at 115.
which ended up in the
Okay.
465
You were
reduction.
provided,
Yes.
Got
Hard
it.
to cut,
got it, okay,
and we tried, and
right. Okay, sorry, I was misreading that, yeah.
I think if we cut more than what you had asked, we probably wouldn't even be here.
Okay.
So you touched on sort of some of your IT needs, sort of the technology out there. Tim Fitzgerald, the county clerk, had talked about, I believe he's delayed some sort of electronic signature effort that he was pushing. So seemed to be some resistance amongst the court. Can you touch on that?
We did launch it, so it was paid for in 2024. I think it went live sometime in 2023. It is so time consuming to review orders that are presented electronically. We do not have the time. I mean, and then if a judge needs to edit it at all, I would love to show you sometime what it takes to utilize that part of his filing software. The salesman did a great job. But again, perhaps if my brain worked in an IT way, perhaps there are ways that we could use that. But it doesn't, the way that it is set up right now is not workable at all to sign orders. It is just really time consuming and frustrating to use.
And so I don't know that we can. I don't think it's resistance from the bench. It's just that it takes more time than the alternative.
But electronic filings, things online, going paperless, I mean, that is sort of the future of courts, is it not?
It is here. We have e-filing, and Mr. Fitzgerald, I think, has it in all 8 case types. And our judges all work electronic. I have no paper in my courtroom when I'm hearing a docket. It's except those matters where we have cases that, motions, I'm taking those home to prepare for, and I take those papers home with me so that I can draw on them and highlight them and ask my questions there on the paperwork. But we no longer require lawyers to go to the court clerk and pick up files. The court clerk doesn't even have paper files in many settings.
Okay,
So, yes,
okay,
absolutely.
okay.
We support electronic filing and workflow. It's when we need to sign something or a judge needs to sign something, it is what could be a minute or two is 5 to 10 minutes. Well, and of frustration too. It's not a very clean process.
Okay.
Ron can come up and I'll show you and then he will vouch for it.
Okay, and then, but wasn't there, there was something that I had seen where the court was requiring physical copies for certain, for motions to be made, right?
We always have required that.
But, well, no, but not allowing those to be electronic though, right?
Because as the judge said, if a judge needs to read a stack of stuff and they would prefer it to be paper so they can make their notes. If we allowed those materials to be submitted to us electronically, then we're the ones that have to print it out and then our costs go up. And so instead, we require that the attorneys provide us paper for the judge to be able to write their notes and review.
And those motions, depending on the docket that you're on, could have literally hundreds of pages of exhibits in a significant medical malpractice case or a big construction project case, or they could just be 2 pages long.
Okay.
Any other questions?
We're right upstairs if you come up with something.
Yeah, no, I think the one thing I would just add is I know as we keep looking across the county for efficiencies too, like on interpretive services, that's been a big push across the entire county is trying to go, is there a way to have one contract for the entire county, not just for Superior Court, not just for the sheriff's office.
Community services.
Yeah, all of that. Is there ways that we can look at that? Because sometimes I hear it's like, oh no, Superior Court doesn't want to talk to other people and other departments don't want to talk to other people. So I'm just putting out there as those are going to be some of the things that we're going to have to really look at across the county as to ways that we can make it a better contract for the county. Still fitting everyone's needs because it's statutory requirements that we have to meet. So, I mean, it's, even as silly as I was trying to get water across the same contract for bottled water across the county when I was in the auditor's office, almost, 8 years ago. So those are the things that I think that we do need to I just want to put out there to all departments that we've got to start looking at those contracts that go across the county that are for the same services that we can provide those efficiencies and probably a better cost for us. So I'm just want to put that out there to all the departments as they can.
Agreed.
sense.
And if somebody says the court isn't willing or the court won't play, please confirm that with me. I mean, I hear that a lot and I really believe that the more that we can speak as one voice, the better that things will be. I mean, I love those cross-department discussions, so. Thank you.
I have one more question, sorry.
No, your time's up. Go ahead.
So I see you took the target number and tried to get
Tried.
there, but there's still a gap, right? So just trying to understand the choices. And if the board only funded at the target level from the budget office, would that require basically a look at layoffs of current staff? Yes.
And that's why we focused a lot more on our workload here, because you hear Tim Fitzgerald say it a lot. We're small as far as staffing for the amount of work that we're doing, and that applies to the clerks, Larry's team, Colin, Victoria, and the courts. And we're doing an immense amount of work, and it takes people. And I'm proud of what we are doing. And I can't see how we could lay off people and keep up with the workload.
And we expect and hope that these offices will be back up to fully staffed, which will then result in additional work that is, we didn't really talk about.
Yeah, no, I appreciate that. I mean, I think that's part of why we worked with the prosecutor's office and are working with the attorneys to get those levels to where we can get those people in. Because otherwise it's, I mean, I hope that we'll see efficiencies and costs, because it's just more cost for you guys and all of that too. Yep. So appreciate that, and we're trying to work on that.
Thank you.
Thank you. Thank you.
Quick question.
Sorry, Scott has a question.
Sorry, Ashley. So, gotta be quick.
Almost made it to the door too.
So in the budget request, it was 505,000 that you had submitted, but I'm hearing now it's 465.
Correct.
Correct, okay. And then I think I saw some email strings on the court moving certain positions from 37.5 to 40 hours.
Correct.
Is that contemplated in your budget request?
No.
Okay. So is that move taking place? And
Yes.
you'll be further short in your budget?
Yes.
So probably need to see what that additional request might look like.
Agreed. When it was approved, we had sufficient costs or sufficient funds in 2024. Again, wages, benefits, we can't even touch those amounts in the software. So yes, we are going to have a bigger gap. Thanks for calling that out there, Scott. Commissioner French.
Oh, ain't tough.
Oh,
So, I've been thinking about your comment about you have not been able to hire or find a court reporter to be able to fill all the courtrooms. What do you think the challenge is? Is it salary? Is it people just don't go into the profession anymore? Is that it?
Yeah.
Okay.
Again,
All right.
if it was a Spokane specific, it was just us that had a hard time, I might think that it's pay. But across the state, across the US, I mean, it's just, there are not enough people in that field. I think a lot of the schools have shut down, and it is a very niche field.
So as an industry then, what can we expect to have happen then? I mean, ultimately, you've got to be able to record what's going on in the courtroom, and I'm assuming electronic recording is got some legal challenges to it. So ultimately, we got to figure out how to overcome this. What do you anticipate we're going to end up having to do?
Well, I think that one, it's almost a return to the past, and we find, I think we're having requests on the benches considering whether or not there'll be voice reporting. So, and that used to be a whisper down system that was used in a lot of old courtrooms before the 9-key. So I think we're seeing a return and a request for us to open up our job description. That will be before the bench, and I think that we'll probably do that. And then I think you're right. Right now, the legal challenges, it's not so much legal challenges as to technology. A record that goes from here to the Court of Appeals or the Supreme Court that says inaudible, that requires 3 or 9 judges or justices to sit down and listen to the entire transcript and come up with their own interpretation of what was said to fill that in is not going to be acceptable. And having microphones at each setting, I have a microphone at a podium and one at each table. I have one. But if someone speaks from the jury box, if someone speaks from the far side of a table, or if council turns it off because they're having a private conversation and then turn it back on, they forget to turn it back on. Those are the technological glitches
Okay.
that we're gonna have to face.
Okay, thank you.
Thank you.
We'll let you get out the door this time.
All right, thank you. Our question.
That's it.
Colin, welcome.
Good morning.
I don't know if you wanna, good morning.
Good morning.
Thank you for joining us today. So now we get to hear your thoughts on your budget.
All right.
Which I'm sure is like all the others were hearing.
Yeah, it's probably not an unexpected presentation you're about to hear from me, but I thank you for all your time as usual. Appreciate it. Some of the subjects we'll be addressing, you guys are very well familiar with, given all of our conversations in the last 12 months regarding funding and staffing and recruitment, retention. So we looked at what was our target budget, which would basically eliminate the current vacancies, I believe as of August. And that's the amount that was requested. So we cannot meet that request. It's not feasible. We can simply not fulfill our legal mandate if we are short-staffed. And that's the bottom line. So most of the requests of what we have is simply to keep positions we've already requested and already been budgeted for in years past, right? So we're not asking for any new FTEs at all. We're not asking for additional staff. Certainly, I think we could use that, but that's another conversation. We're simply asking to fund the current vacancies that we have. We are also asking for, and this board is familiar with this situation as well, additional funds for, I believe we call it legal. That's right, Michelle. But it's basically the private conflict attorney costs that we've been facing as a result primarily from the vacancies we've had, but also legitimate conflicts. As this board's aware, our office takes in cases, we're assigned for pretrial services. If there's an actual conflict, it goes to Victoria's office at Counsel for Defense. She has a conflict, it goes out to private conflict counsel. Victoria and I both have been sending cases that are not, I believe they are conflicts, but we won't call them conflicts for this scenario. It's simply overflow, right? We don't have enough bodies, we don't have enough attorneys to assign to these cases. And so private counsel has picked up the slack to some extent on that, which is excellent and great, but we have some issues there. One of the issues we have, just grab this. Let me back up for a second. We're also not asking for, so again, we're asking for the FTEs that we already had to be funded. We're not asking for any additional money in other places. 87% of our budget goes to personnel, salaries, benefits, insurance. We're not asking for increased budget for supplies or office space, technology, training, even though as this board's clearly aware, we have had our office get younger, much faster and less experienced than we expected. So we certainly could use more money for training, but that's not part of the presentation. We've been creative with it. We're going to continue to be creative with solutions on that front. We're using our resources at the Washington State Bar Association, Washington Defender Association. Victoria and I do in-house trainings. We have a mentoring program that we do through supervisors and trial work. So we are not asking for more money in other places. We're simply asking to be funded for our current FTEs and then the private conflict costs that I want to get to that too. So previously in 2023 and 2024, we have a $300,000 budget for those private conflict cases. Over the last 2 years, we have exceeded that, almost doubling it in 2023, and we are projected to more than double it in 2024. So we can go to the next slide. So that request one is the amount we're asking for on the private conflict contract side of things. that additional funding would not only cover what we're currently paying, but in addition, we are asking for an increase in the hourly rate for Class A felonies from $70 to $110, and an increase in the flat rate fee paid to juvenile and misdemeanor private attorneys for the cases they take. One, those rates are more competitive with other counties, so that would be helpful. But two, we need to attract more attorneys on the private conflict list. We have three that are qualified right now to take Class A felonies, but only two that are really doing that heavy lifting. And if they choose not to accept the case, of course, the contract doesn't require them to, we're in real trouble. And it's gonna require myself going in front of possibly Judge Fennessy or others and saying, hey, I don't have an attorney to assign to this case. So this has been an issue for a few years now, but thankfully the two heavy hitters that we have taken up a lot of the slack. But they're also getting paid a lot for that. So we'd like to increase and add some additional attorneys to the conflict list. And in my opinion, the only way to do that is to increase rates. And also even the ones that are, as this board knows, for the standard of indigent defense, you have to have enough years of experience in felonies, general experience, trial experience, appellate and or legal research and writing experience in order to be certified to take certain kinds of cases. So again, we only have about 2 or 3 that are Class A certified, or 3-strike certified, homicide certified, sexual assault certified, and really only 2 that are doing the heavy lifting. So hopefully if we're able to change this rate, we would be able to attract some more of those folks and then not be in a position where I'm going in front of the court and saying we don't have someone to assign this case. And the consequence of that, I know the board's familiar with, but I'll readdress a little bit later as well. So that's part of the request. Also, if we are fully staffed and if we get to that point, which, and again, I'll get to in a minute, we've already made strides toward, I think some of this is going to offset, right? I mean, part of the reason the private conflict costs are so high right now is because of all the vacancies that my office has had, the Council of Defense has had. That's why these cases have gone to private attorneys under contract with us. So while I'm asking for 340, and I think that would include the rate changes, I don't expect, especially if we get fully staffed, that we would end up paying that much. I think it would be substantially less than that. And I'll get into more of the details as we go further.
So I'm just gonna ask a question. So the previous slide you had, that basically was $1 million
Correct.
difference between the target. Was this included in that or is this in addition to that?
This is included in that.
Okay,
So this is just breaking down that $1 million request into
Okay.
parts.
thank you.
Yeah, sorry, that wasn't clear. Yeah.
No.
Next slide.
Some people are coming in with additional requests on top of, so that's why I just want to make sure, for the public, anyone watching as well as here.
Thank you. Just a question.
Yep.
On the 2 pieces of the request.
Yes.
Part of it is to maintain budgeted dollars for all vacant attorney positions. How many is that? What's the 714 get you in terms of body?
Essentially 5.
Body.
Correct in that.
And if all of those were filled, say a little prayer, does the private conflict need then reduce?
Right, that's
Okay.
exactly right. Yep.
Okay.
So how much, if that's your next question, I don't have an answer for you on that. It depends. It'll depend on whether or not we change the rates and compensation structure for those folks. And then it just depends on a variable we don't know yet. Either just Larry, I'm sure, is how many filings, right? The more filings we have, the more bodies we need. We don't know that number, and it does fluctuate from year to year. So.
But to follow up on that, would it be fair to say though that I guess I see where you're going with this. So if you prioritized request 2, potentially the 340,000 would go down. You don't know by how much, but likely it would.
Correct.
But that's all contingent on filling those 5 positions, which has been a challenge.
Right. Well, and then again, if we don't fill the positions, you're not spending as much for the request 2, which is the 714.
So maybe that $1 million number is actually lower
I think it is.
realistically.
Absolutely, I think
So
in
it's
the
trying to figure out
past-
what that
Yeah.
number is.
In the past, when we have been full, our legal has been anywhere from 250 to 300,000. So it's cut in half when we've had full positions. So I think we can estimate definitely less 300,000.
All right. So part of our analysis included, well, how likely are we to fill those vacant positions? And again, this board is very familiar with our requests and recent changes to attorney one compensation structure, as well as moving from 37.5 hours to 40 hours for attorney in our office, which, by the way, we've already seen paid dividends. So thank you for that. For example, we have 7 qualified applicants in the last month. Previous 8 months, we had 15. So already we've seen a significant spike there. We potentially have 6 new hires in the next 2 months. And I mean, 6 have accepted offers as we sit here today. So as we're moving towards staffing, I think it's very likely that we'll be able to fill vacant positions. I can also tell you anecdotally, I had an attorney pop into my office about 2 weeks ago, planning on moving to the city public defender's office, then heard we were moving to the 40 hours. I guess it was more than 2 weeks ago. And then also she's an attorney one, and her salary was going to get adjusted based on this commission, this board's approval to then adjust the attorney one structure. So she is now stayed. So we've been able to retain her, and I've heard, word of mouth that maybe 1 or 2 more have also decided to stay. So it's already paid dividends, and I very much appreciate the board's work on that. So it is happening. It is being successful. Hopefully, I guess I'm cautiously optimistic that we will be able to fill the vacancies. We still have a problem with retaining our highest paid folks, which are also our most qualified folks, right? Those are our attorney threes, our senior attorneys that are doing the most serious work. Again, that's the class A's, the homicides, the sexual assaults. As this board knows from prior, but I think it bears repeating. Presentation, I believe 7 of the last 8 to leave our office were those. So that is still a huge concern. And again, I think some of that concern could be offset if we were to find more class A qualified attorneys on the private side that can fill some gaps while we try to train and get some of those younger folks qualified to do that work.
So Colin, so just educate us again on why are they leaving? Because it's not necessarily the pay, is it?
Burnout, yeah, I think is the biggest one. And I think Victoria probably sees that as well, right? I mean,
They're the same.
yeah, so right now, as the board's aware, there are proposals in front of the Washington Supreme Court from the Washington Bar Association, the WDA, the ABA, to reduce caseload standards, right? It was based on an antiquated system that didn't include all of the new things that attorneys have to deal with in litigation, body cams, DNA, work video surveillance, cell phone technology, all things that have to be reviewed with clients, reviewed and analyzed before, cases can be resolved. So given the amount of time it takes to do that and the number of cases they have, the job simply can't be done the amount of time that's required. So it requires us to prioritize. Each individual attorney has to do that. And while to some extent they can be successful, I think there's a good chance some things are getting missed at some point, right? So
Are you doing a waiting system within your office?
we don't have a waiting system. Now, some counties do have waiting systems, which would help significantly. Right now, we just have a case to case. And if you're in felonies, that means you can take 150 cases in a 12-month period, and that's it. Case waiting would reduce that, but then you would need the staff to accommodate that as well, right? Which may need additional attorneys.
Would it help temporarily, I guess, just on the burnout side?
Yeah, and I think both Counsel for Defense and my office have tried to do that as much as we can, but we also want to make sure that we're meeting our legal mandate, right? And that indigent citizens here in Spokane County have representation. So it's difficult. We're kind of walking that line constantly. So yes, that would help. If I could have the next slide, please. So if we were only to receive the assigned budget amount discussed already, what would that mean as far as fulfilling our legal mandate to provide our services? Well, there's quite a few problems associated with the decrease in attorney positions, lead to higher attorney caseloads. We talked about that. In my opinion, it would add burnout. So we're gonna have more turnover, more recruiting issues. You're gonna have that issue. You're also going to have criminal cases dismissed or not filed. I know Larry's office right now has a backlog of nonviolent property offenses they haven't filed because they're short-staffed and we're short-staffed. Now the court's short-staffed. So because of those issues, you have cases that aren't filed. But ultimately, if you don't have representation, you're you're gonna have cases dismissed. You're gonna have situations that we've talked about before in Oregon and Yakima, and I'll get into those here in a minute. So rise in burnout, you're gonna lose more talented and experienced attorneys, which we've already seen. You're gonna have difficulty in complying with the Supreme Court indigent defense standards. And again, the real problem here is those folks that are most qualified, that have 4+ years of experience, 4 or 5 felony trials, and that are certified to handle the most serious cases. So, in addition to that, we won't be able to do what we're supposed to do, right? So it creates potential civil liability, and I'll get into that later. More cases sent to the conflict office. We've already discussed this, right? So CFD will be then overburdened, but of course they can only take so many as well. So then those cases automatically flow to private counsel that have contract with us. We've talked about it already, but you can see from the slide, I believe in 2023, we had almost $600,000 in cost. And in 2024, we believe we're going to have over $600,000 paid to private attorneys. And you can see in years past, now some of this was related to COVID and plague, we paid a lot less. Closer to 252 in 2021, and I think it was 341 in 2022. So conflict costs have increased, and I believe the primary reason for that is the overflow in cases that private counsels had to take because of our staffing issues. That's an issue. In addition to that, so you've got criminal cases being dismissed or not prosecuted, also ultimately leads to, if I can get the next slide, a reduction in confidence in the system. Right. So part of the problem is if you don't have attorneys assigned or you have a lot of turnover, you're going to have delays in case resolution. We've seen that already. We have some cases where there are 4 or 5 different attorneys assigned to an individual case without resolution. That's due to turnover, right? So we'd have an attorney assigned. 3 months later, that attorney leaves for a different, higher paying, less stressful job, and then another attorney is assigned. Then we see that happening again. Now, it's not on every case, but we're seeing it happen quite frequently, too frequently. And so delays in the system, you've got cases taking longer to resolve. So instead of from 6 to 12 months on a felony case, which is I think what everybody tries to do, you're getting more than a year, more than 2 in some cases, depending on the situation. Also, you get increased costs associated with those delays because I know you all know that. Part of it's going to be the jail. Part of it's going to be private conflict attorneys. You're going to pay more pretrial to house folks. Jail's going to be full. So there are ancillary effects to not having enough public defenders. Criminal cases dismissed or not prosecuted. We talked about that, but I wanted to get back to it. There's a case out of Oregon where the federal defenders essentially sued the state. Oregon has a state public defense system, so it's a little different than Washington. They sued the state. Decision came out that's up there. And essentially, the Ninth Circuit said that if an attorney is not assigned and that individual being facing charges is in custody within a week, then the case will be dismissed. So that's what's happening in Oregon. I believe there's a secondary lawsuit as well, class action lawsuit against the state for unlawful restraint, which is kind of what we're seeing in Yakima recently. The ACLU has now filed a suit there. I'll get into that here momentarily. So again, reduced confidence in our system. And then there's the community safety concerns. We've had this conversation before, but I think it bears repeating. The system only works if all the parties are properly funded. That means the prosecutor's office, that means counsel for defense, that means the courts, that means the clerks, that means law enforcement. It only works if everybody has the bodies they need. And I know this board's aware of that, but I think it bears repeating. So if we can move to the next slide, please. So more on the Yakima suit. So again, the ACLU has essentially filed suit there. They are suing Yakima County. They're suing Yakima Superior Court, Yakima Department of Corrections, and a few individuals in Yakima County for simply not complying with their constitutional mandate, right? Sixth Amendment right to counsel, failure to provide due process, speedy trial, right to representation, and then also unlawful restraint, not only for those that are in custody, restraint's obvious, they're in custody, but those out of custody folks that are under release conditions, right? The longer cases are delayed and the more release conditions they have, it can be punitive, right? They're paying more in whatever conditions they may have, whether that's UA testing or some form of treatment or ignition interlock device, whatever the case may be, they're paying more pre-trial. It affects them, it affects their families. It also longer time for delay, then maybe they're not getting back to their families. Maybe there's certain restraining orders in place, et cetera. And again, more disruption. And I think you see eventually more. So that's where we're headed. We are not there yet. I've been in court a couple of times, I think as this board's aware, saying that we don't have an attorney to assign the case. We've creatively tried to solve as many of those problems as we can. We've reached out to Stevens County a couple of times to see if they can take a case or two. So far, we haven't been successful, by the way, but we're trying. But that's where we're headed, and Yakima is a great concern to us. So,
Go ahead.
I was gonna say, and I believe, I think also is the commissioners were being sued as well.
correct,
And, yeah,
correct.
because it wasn't just all the courts and all
No,
that.
no,
the
there's some
commissioners as well
individuals
are
being
getting-
sued.
Getting
Yep.
it. Commissioner Jordan.
When was that filed? You know, any rough time frame?
Relatively recently, Victoria, do you know, or
It was last week.
was it last
Oh.
week? Yeah, and it was recent.
So how many times have you had to go into court and say that we don't have an attorney?
Twice. Once in the juvenile setting, we have now found an attorney. Thankfully, risk management worked with us and we were able to restructure some of the insurance requirements. So Victoria and I worked with Mike and we worked with risk management. We were able to change that contract. That helped. We immediately got two attorneys that were juvenile qualified. One of them accepted that case. So that problem was solved. There's another case that Judge Fennessy is very familiar with. We still do not have counsel for. That individual is in custody. And it's gone through my office, Victoria's office, and multiple attorneys that we have contracts with. And again, we don't have any more qualified attorneys to take that matter. Judge Fennessy has court ordered us to look elsewhere, and thus the Stevens County phone calls and emails my office has been making. Other questions?
Colin, the budget that you had submitted had a request of $840,000 additional. So from your presentation today, you're now requesting $1,054,000?
Yeah, Scott, and I wonder if you've got an old version. We had to adjust that based on salaries, insurance, benefits. And in fact, it is in
The
line.
attorney
with-
one,
Yeah, and it is in line with what we had for the general fund. I think that was sent out in the email for budget. So essentially, it puts us with all included vacancies at a total of $10,826,000.
Okay, so what the board has is the request that you guys submitted of the 840. So I just want to make sure.
Okay,
The
so
board's aware
I
that there's an
apologize.
additional $14,000.
Yeah, I apologize. We realized this weekend that number didn't include all of the expenses associated with those FTEs. So we added those back in. I thought I sent the right copy, perhaps I didn't. So my apologies.
So one more on that total then, 1 million what?
$1,054,000. That was on the slide that Colin had. But what you'll have in your budget package
Yeah, let's
is
say
for the submissions or the
Gotcha.
40. Yeah.
Thanks, Scott.
So on that note, do we need to update those materials then? I'm looking at Tessa.
I'd like to have,
'Cause I mean,
We'd
well,
love to get it all lined up.
well, no, I mean, the board made the decision to make the change with the attorney one positions just recently. So of course, now you have to recalculate those salary and benefit costs, and that's why I think you see that discrepancy. So I was just thinking if we could get an updated packet with those updated costs in there. I'm assuming that Larry's office as well probably has a change from what they submitted like 2 months ago, since we made that change in the last 2 months.
right, and that would be the departments who would submit them, the
Okay.
updated budget request, additional budget request forms so that our budget office can update the forms for the
Okay.
commissioners. Yeah.
Okay. that'd be
That's why I
great.
raised the
mean-
question to Superior Court as well earlier. Just making sure that
Oh, because
you all
that
know what the
was,
requests are. So
right,
when you're going through your matrix, the correct number is in there.
because they were talking about moving some folks to 40 hours, which also changes the number, so.
That they're asking
Okay.
for. The
Yeah.
target budget doesn't change. It's just what their ask is. Additionally, we want to make sure you have the correct numbers for them.
Okay, and so Tessa, when those start to come in and you are able to put them into the budget program and update the large PDF document, will you just give us heads up when that happens? So we know it's been updated? Yep. Okay,
Anytime we get something new from the departments that updates those, revises those, we'll go and make sure they're reflected in the commissioner's package.
Right, cause I wouldn't know to look and see if it was a new PDF that was uploaded, so just, yeah, okay, gotcha, thank you.
Have anything else unless you guys have additional questions?
So it sounds really hopeful, I guess, that you have a lot of qualified applicants and you're interviewing and hopefully filling. I know there's always movement, people coming and going just naturally over the course of a year from your office, but it sounds like it's very, very likely to fill those positions.
It's looking that way right now for sure.
So does that mean that we could potentially reduce the budget for the private conflict costs?
Yeah, I think it'll take a little bit of time before you'll see that offset, but you
Right.
will see that offset, yes.
Maybe like
Again,
half of it, knowing mid-year you have your attorneys going and taking on full caseloads and such.
yes, it'll depend on a couple of things. One, the filings, as I already mentioned. It's also gonna depend on whether or not we can retain those most senior folks. Because oftentimes, we only have so many folks certified to take those cases. If we get in a situation where,
And
while
you
we
have
fully
to,
staff, but
yeah.
they're younger and they're not certified, then those cases are gonna go to Victoria's office. Victoria's gonna say, well, we're full. They're then gonna go to private, right? So there could be some overlap. But yes, eventually that is where I expect it to head. And I'm relatively optimistic about that. We even had one attorney that I think is gonna come back from the AG's office. As you guys all know, we've lost quite a few over the last 2 years. So, yes, I said that just for you.
No comment.
Culture, Sue Jordan.
So in 2024, we're expected to be double the budget amount for the conflicts, right? Because the budget was 300,000.
Correct.
You're just covering that out of salary savings as you're able.
Yes.
For now.
Well, and that's exactly what happened the year before. So in
Yeah.
2023, we had those vacancies, but they covered
Yeah.
the additional, whatever it was, $275,000 in cost for those private conflict attorneys.
Can you explain, because the conflict attorneys happen right now is happening because of being short-staffed. But there's also legitimate reasons why you have to have conflict attorneys. So can you just explain that so people understand that? It's
Absolutely.
not just the short-staffedness, that there is gonna be some cost there.
Sure, well, I can use the juvenile case we just talked about that I had to go in court and say we didn't have an attorney to assign as a great example. I believe it was a drive-by shooting involving 5 defendants, all juveniles. My office accepted representing, the responsibility of representing 1 individual. Victoria did the same. And then we had 3 others that needed to be assigned counsel. So then we start going through the private conflict contract list because our office can't represent 2 of those folks. My office can't represent 2 of those folks under the rules of professional conduct, rules of professional conduct. Yeah, we can't do that. So it has to be assigned somewhere. And so it was assigned to private conflict counsel.
And then I guess just to educate me on the flip side, on the prosecutor side, we've got Larry here, but you could probably speak to it. Can the prosecutor's office, they have different attorneys? Is it just one prosecutor then on the case against all 5 of those?
Yes. I mean, Larry could certainly add more to that, but typically, yes, I think sometimes the more complicated litigation, they'll bring in, like we do, multiple attorneys on, but otherwise, yes.
In most instances for us, even in the most complex cases, we'd have 2 max. For 5 co-defendants, we might have 2. Juvenile, just depends on which direction they kind of go. If you end up in a trial and for whatever reason, they're not separate, there's no Bruton issues or anything like that, we probably would have a couple lawyers at the trial. But seldom will you see more than 2 prosecutors on any one case.
I think it just helps us understand.
We don't have the same legal relationship with anybody on that side like Colin has to deal with pretty much every day if there's more than 1 defendant.
Thank you.
No, thank you.
And are we seeing more of those type of situations too?
Yeah, I haven't looked at the numbers, but anecdotally, I would say, yes, we are seeing more of those situations.
It just helps. I mean, we don't have a choice. So in paying for these things, we're gonna pay for it one way or the other. So I mean, which is, honestly, I can say when you're saying you're gonna get you know, you've got people applying and all of that, and gave me goosebumps. I was very excited. So that's exciting to see. I mean, it was like, yay, but it's finally, you know, all of those discussions, all this year are paying off and will make a difference. Because yeah, we can have you short staff, we can have you cut people, but then it just means we're gonna be contracting out and paying a higher rate outside the county. And those are the tough decisions we have to make as we look at, you know, budget decisions as to what's required versus what's discretionary. So, you know, and I think Victoria and I had a chance to visit, you know, this last week. And so, you know, it's the same thing with Council for Defense. You know, what can't happen in her office goes out. It is concerning that the people that are, you know, level A, I don't know, Class A certified, is that what you call it?
Yes.
You know, that can handle those serious crimes are leaving. So that's, you know, because then if we're contracting those out, that's a higher, I'm assuming a higher rate.
Correct. It's a $1,400, I believe, flat rate for the first 20 hours. And then after 20 hours, the current rate is 70, but our proposal is to move that to 110. Because again, when we're talking about the complex litigation, you're talking about the body cams, you're talking about the homicide cases, you're talking about the DNA, cell phones, all of those.
Attorney rates are higher than that out of the
Yeah,
world.
they
so.
are. But as far as public contracts, it gets us in a more competitive place. And that's the other issue, right, is that's part of the reason for that request on that side of things is we need to incentivize more private attorneys that are qualified, and there aren't that many of them, to take contracts with us. We don't have that right.
Do you have any data on kind of what that rate's been historically that you could share, or any kind of objective basis for setting that rate?
Yeah, we've looked at a few of the counties. I can get you the data and the information and
We're pretty
historical.
even with what other counties right now.
We would be with the adopted changes from what I've seen. That's closer on the juvenile, especially the juvenile misdemeanor cases, the 1,200 flat fee. And I think even the other ones, I think there's a few counties paying quite a bit more hourly than the 110. But I can get the board that information. Sure. Yeah.
So one question, as I was meeting with law enforcement, they were talking about new juvenile, with the state maybe raising the, I don't know, levels for juvenile crimes. And basically if you're under 16, that if they commit a crime, it's like, that doesn't really count. What's that? Are you guys hearing that?
I haven't heard that. No, I don't know if Victoria might have more information on that.
Did I hear you correctly that it's like it doesn't count as a crime?
Yeah, like right now, law enforcement can't talk to kids, you know, so, and that the state is looking at further laws that are gonna make it so if you're under 16, that they're really not gonna say you committed a crime.
So I haven't heard that they're not gonna still file charges, but there was a change in the law where juvenile offender history, which is their criminal history, so anything they are convicted of, is not going to account in their offender score if they reoffend as adults. So right now, under our sentencing guidelines, how many prior felonies you have, and depending on what type of felonies, gives you so many points, which puts you on a higher range as to what your presumptive sentence is on whatever you're accused of as an adult. And if it's not a murder or Class A sex offense, any juvenile adjudication, as they're called, not convictions, are not gonna count on that adult guidelines. So I think it's caused some fear that means kids are gonna just run amok because they think it's not gonna affect them as an adult. There's still the consequences that they're gonna receive in the juvenile court process, but it just, the criminal history doesn't follow them into adulthood.
Okay. I may follow up with that. And I think they're just hearing that this is a potential new legislation that may be coming, so. Yeah. Things to consider, and as we know, as state continues to do different laws, as we heard with Superior Court, it puts more burden on Superior Court that really are those unfunded mandates that we're all having to pay for, that we've got to continue to keep figuring out. So it's interesting how little changes in one piece of the system then has a financial effect on the county. So as well as we know with the caseload standards, will have a huge effect on counties that we will be required to pay. Because I think we're about $11 million a year. And if we go to half those cases, you know, for caseload standards, I mean, that's $11 million we don't have. And that's just at today's cost. So, yeah, concerns.
Yeah, following up on that, Madam Chair, it might be interesting to look at, I really thought that the Superior Court's presentation was good about the changes around the landlord tenant laws and requirements around, court hearings, and then while the state is paying for the defense attorneys for defendants, they're not paying additional costs for the court hearings and the longer hearings and the potential trials. And then also there was a couple, and it might be something, I didn't know if WASAC was looking into, in this next legislative session, if some of these new requirements also for what was the other thing? It was getting protection orders and those types of orders. There's a lot more requirements that the court's hearing on that as well. Anyway, just wondering if WASAC was looking at some of those impacts and whether we want to, go to the state and say, hey, you covered these things, but then there's these other impacts to the court system that we would appreciate some funding for.
Yeah, I think
It's hard to itemize it.
Instant defense right now is the big push that WASAC is making. And as you know, even with our legislative agenda, you've got, outlets, Commissioner French is on the LSC for WASAC. You still have to, narrow down your requests because you can't do everything. But it's partly, Larry's office is looking at the laws that are coming down, and WAPA is looking at, their main issues. I don't know if public defense, if you guys have a group that lobbies on your behalf.
Yeah, I do. We're all right now dealing with the possible changes, to those standards.
I guess we have to wait and see what happens with that first. Yes.
Yeah.
Before we go to other issues.
Well, and I think, was the last listening session for the state Supreme Court on the caseload standards just recently?
Yes.
Yeah, so I think now they've closed the comment. public
No, I
comment.
think there's another.
The written comments are open until October 31st, and then there's another public session early November
Okay,
with invited speakers again.
yeah, I mean, I think we're all focused on that. So then, all these other things are potentially happening and we're not even aware. And what if we are gonna have? I mean, I think even the LSC for WASAC, it's divide and conquer.
Well, and it, with the new structure and stuff for voting and everything, it's a little bit interesting, but November, we'll probably finalize out our legislative ask, at least for the initial opening of the legislature, and then that gets modified, basically every week, every other week, as we see more bills come out and learn more about the amendments and stuff. So, but yeah, we're about ready to enter the fun season.
Yeah, we are, especially with the long session and
Yeah.
budget. And I would say if there is any bills out there that you guys are paying attention to, it's good for us just to be aware. I mean, we're, again, we can't try to defend everything. But the more awareness that we have that are, to each department, the better it is for us when we do go to Olympia and are having those discussions.
I did see
Commissioner French, and then I'll go. No, you're good.
an email come through that evidently we are going to the Superior Court or Supreme Court either this week or next week with regard to the indigent defense litigation and stuff. So we don't know what the court's going to rule on that. And hopefully, it'll be favorable, but if it's not, that creates a whole nother disaster for counties.
Yeah, I mean, literally some counties could go bankrupt.
Yeah.
Not just that, so.
Thank you, Commissioner. I just wanted to say, since you brought that up, it stimulated something so the caseload standards for public defenders comes in several stages. I don't know if you know what they're gonna end up, Victoria or Colin, at the end of it, but they're gonna go down in stages so that several years from now, compared to what would be 100% public defender caseload today, what would that percentage look like at full implementation several years from now? Because that's a planning factor, I think, for the board as we move along, but I don't know the number off the top of my head.
I think it's 50%. It's going from 150 to 75.
Yeah, so you'll
As
need
well as
double.
they're adding staffing requirements to it as well.
Yeah, what it's worth.
I don't know.
Go ahead.
It's
Sorry.
the way it's proposed and the way the Washington State Bar Association has adopted it, it's a 3-year implementation. The first year starts July of next year. It goes to 110, then there's a further reduction, and by the final year, it's 47 case credits max for felonies for juvenile and adults, which is a bigger reduction on the juvenile side than the adult side. But within that 47 case credit max, there's case weighting for each type of offense. So, a 3 strikes or class A sex offense is going to be 7 of those points of that 47. Whereas right now we're operating with 150 and it doesn't matter what the charge is a case, at least here in Spokane County, because we're an area that has an adopted case weighting. But Larry, we did, they created a calculator that we entered our numbers that projects out what our staffing and attorney needs will be based on that implementation phase.
Perfect, yeah. I didn't know.
And I believe we've sent that out at this point as well. And again, those are the standards that haven't been adopted yet. They may tweak them.
Correct.
Right. And that was, those were sent into WASDAQ, so we could accumulate all that information. So we have the data and the numbers to show the legislature and whoever else gets to hear. Commissioner French.
Yeah, and with regard to the phasing in of the program, I've heard commissioners on both sides of the state talk about, define it as death by 1,000 cuts. That, instead of just killing us all at once, they're gonna kill us over time. But the ultimate outcome is gonna be, we just can't afford it, not unless we tax our citizens to death. I mean, it's just, the cost is gonna be substantial.
And I believe in the state of Washington, one of you can correct me, we are like the lowest, the state pays the least amount for indigent defense across the entire nation.
Yep, that's correct.
Accurate, so, yes, so the state has put it on the counties and the citizens at the county level. Versus most other states, the state pays for it, because it's, which is part of the lawsuit is that it's constitutionally a state function.
Well, and what Commissioner Cooney mentioned with regard to some counties are seriously looking at having to go bankrupt. That is a viable outcome, because if they go bankrupt, then it forces the state to come in and pay for it. And, for some of the smaller counties, that might be their only option. So.
Colin, thanks for all the good news.
Every time I feel like I'm giving spreading cheer to the board.
You have one set of good news, which is you have attorneys applying to work for the county.
Yeah.
Excellent.
And as always, we appreciate your time.
Focus on that.
No, thank you very much. Appreciate it. Does anyone else have any other questions? I'm sorry, I should make sure.
I won't get up like Judge Finnis did and tell one.
Exactly. Well, thank you. No, we appreciate it. I mean, it's just information we all need, and we need to understand that we don't have a choice here, which is why I think from WASAC's perspective, we're really trying to fight it.
Appreciate that. Thank you all.
Thank you.
Thanks for allowing me to join.
Yeah, no, thank you for joining. Yeah, okay, so that takes us to the end of our agenda today, other than do we have?
Just a couple of the reminders. So we'll have the prosecute, so next week for budget presentations, we'll now have sheriff, prosecutor, and assessor. And we're gonna move scraps out to the 21st. So just an update to the budget presentations that are coming.
Couple miscellaneous.
Oh, on that list, did we also want to include the district court? I haven't had a chance to dig deep into there, but I don't believe they were able to come forward with the full amount of budget that we were asking. I'm guessing similar challenges as Superior, but just wondering if we wanted to hear from district court as well.
You can add them if that's what the board wants.
See if they can make the 21st.
We'll reach out to them and see if they can get scheduled.
Okay.
Any other ones that you're thinking about?
That was the only other one I asked. It's the only one I was thinking.
Okay, so a couple of miscellaneous things that I want to bring up. As we've had our public hearing, open public forums, it's come up that people are feeling I'm, as the prerogative of the chair, feeling that I'm changing the rules as we go. So one of the items is the allowing people to yield their time to somebody else. So I wanted to bring that up today as a group, so we could discuss it and decide if we want to look at changing the way we do that. So I think I would propose that we, talking to other municipalities and other organizations, they don't yield their time. And so I think I'm okay. I would propose that we will not yield their time, because as we've seen, when we have multiple people, I'm having to reduce the amount of time, and it's a coordination that does have to occur. So that's why I need to know who's yielding their time, all of that. So I would propose that we just do away with yielding our time to somebody else. They can coordinate. We've seen it at the health district in years past where people know. So one person gets up and reads 3 minutes of a statement. The next person gets up and reads the next 3 minutes of that statement. I mean, so there's all kinds of ways that people can do it with
Creative ways.
yes, creative ways to do it, which are fine. But I think, just so I don't want people to feel confused when I'm not allowing it, or feeling like I'm restricting them in some ways. So I would just offer that we would change our rules to not allow people to yield time. Thoughts?
Is there currently reference to that in the code?
There is, that's my understanding. It's up to the chair to authorize someone to share their 3 minutes. As the board knows, in a code county, you're not legally obligated to have an open public forum. But we have opted to allow an open public forum, and then we have the ability, which Commissioner Kuhn has indicated, to adopt guidelines reflecting that. And so we would have to go in, Commissioner Cuny, and modify that particular provision to eliminate the ability of the chair to allow people to share their 3 minutes.
And if I remember, maybe it was the end of last year, early this year, we had a discussion about this very topic, and I don't think we ever finished the discussion. We talked about ways to make public forum better, because I remember I called some folks at the city of the valley. I think I talked to Deer Park. I called around to other cities. I couldn't find anybody that allows folks to bundle their minutes together. 3 people say, okay, this one person gets to speak for 9. I couldn't find anybody that actually does that. So I would support exactly what you were saying. And I think I remember saying, like, hey, if you have something to say to us, just come up and say it. There's no reason for anybody to be afraid to step up to the microphone and talk to us. So we like being accessible, and I think that's a great way that shows we are accessible. If you want to come talk to us, you can come talk to us.
So Jim, you were just saying that's not in the code. It's like a separate, we have like a meeting policy.
That is correct,
right?
Commissioner
Okay.
Kuhn, and I misspoke. It's not in the county code.
Okay.
It's a separate policy that we've adopted guidelines for speaking at the open public forum.
And I think we were looking at those because it kind of needed to be looked at and updated, but we never,
I don't think we ever completed it.
yeah, I would like to
I
take a
don't know
look.
why.
I think your suggestion is good. I would like to take a look at the whole policy and see if there's other things we might want to tweak as well. I think we need to be very clear, and it says it right now, but maybe we need to underline it or reword that at the discretion of the chair, you have up to 3 minutes. So that people realize, oh, it may not be a full 3 minutes. And I think it says it in there, but I think we can just
You're
be
right, because
more clear about it.
yes, you're right, because there was something said up to, but then another, but I
And then
think
they
the
said-
slips
the slips
themselves
said
said
Yeah.
at least or something. Or so, yes, no, the slips were up to, and, but there was some verbiage on there that left some kind of gray area. I don't remember what exactly it was, but I remember that
The
that
other,
was an issue.
the other question that I got a constituent reaching out after last week, I don't think they had been to one of our open forums before. I do think a lot of the other cities have gotten rid of giving your full address at the beginning of the meeting. So again, these are just things that I would like to look at the whole policy and figure out like what needs to be kind of updated, you know?
I don't have a problem with that. I mean, it's just always been tradition to.
Right, and we had that as a city way back, I'm sure Commissioner French, it was a traditional thing, and then I think within, I don't know, by 2013, 14, we got rid of that at the city. And so, I mean, just if someone were to give their address, and I think, you know, if there was who knows, but it's like a privacy issue if someone were to, you know, go find out where you live or something, it's just a little concerning to some people, I think. So, you know, if there's
Yes.
an issue that's
There is an issue with asking people to give that kind of information, and I think that it just hasn't found its way into our policy. So, Madam Chair, what I will do is I'll pass out to all the board members a copy of our present policy. And then did you want to have, commissioners, some sort of further discussion once you've looked at it, maybe in a week or so? And so we can get some direction in addition to the one we've got about the 3-minute policy?
Yes, I would say let's put it on next week's Tuesday agenda or Monday after, you know, just to follow up, just so we get it finalized. Because it's just something that needs to happen, because I just want to make sure that the citizens are clear. I will be zooming in tomorrow, so you'll be chairing the meeting, so.
Be Zoom morning and afternoon?
No, I'll be here in the morning for most of it. So, you know, you may just want to reiterate that we have this discussion. It's your prerogative tomorrow to then say
City's policy and send it out.
on how many people show up, that we won't be late.
Will do.
That way it's clear that we have this discussion with the board.
we updated it like 30 times.
But it's in your.
Commissioner French.
What's the consequence if you violate the policy?
Well, I think,
That needs to be in the policy.
We bang the gavel and we say you're done.
I mean, and I try to be very clear that once your time is up, your time is up. Because what I have been trying not to have happen is people thinking they can continue.
Yeah.
And so I've tried to make sure that I've been very clear on that, because we just have to. Otherwise, people keep going.
You've been doing a great job. My comment wasn't about you. My comment was about, you know, if somebody comes up and violates the policy by continuing to talk or whatever policies we ultimately do, what is the consequence? Because if there's no consequence, there's no enforcement. If there's no enforcement, then why have the policy? That was my only question in terms of.
You know, Commissioner French, since we've had our public forums, I don't recall ever being an issue about enforcement. I really don't know that there has been. We know under the Open Public Meetings Act, if there's a rowdy group there, there's a process that we can go through to clear the room and relocate. But under the Public Meetings Act, it doesn't address this unique feature. But what I will do, Commissioner French, is, as I told Commissioner Waldorf, I'm going to go into the cities, because they've had this a lot longer than we have, and I'll see if I can find what they have in their commissioner. And also, I know that MRSC has quite a bit on this, and I'll try to send that out, so when you look it over, you can see those options, Commissioner French.
There was a period of time when I was on the city council when we had some folks that abused the process and stuff. And so, as I remember, and appreciate you validating this, is that if you violated the policy, then you'd have like a 30-day period where you could not provide any public testimony, at least at the mic. You can always submit something in writing, but you just couldn't do it in the mic because it became disruptive. Ultimately, that problem went away because people became very compliant with policy, but just a thought.
I'll check that, Commissioner French. The city's charter, if I recall right, requires an open public meeting. Their charters, fortunately,
Yeah.
let me take that back. We don't have those same obligations they do, but
Right.
Commissioner French, I'll certainly look at that and share that information with the board.
And you can look at the city of Spokane Valleys.
I
as
will,
well.
thank you.
So
I will, Madam Chair.
they've been
Yeah.
doing it for 20 years.
Wasn't there something a couple of months ago, or earlier this year, something about at the city specifically where remarks had to be addressed to the council president down there and you couldn't use names of individual council except for the council president who you were to address. I don't know if we want to go down that road or anything, but I remember there was something to that effect they were dealing with.
We have,
That's Robert's
Yeah.
rules.
they
Yeah.
have to direct it to me.
Well,
Right.
but they had something, they
And
they had some
retracted.
dust up where it was like you couldn't use that, you couldn't even say like, directing it to Commissioner CUNY, say, and I, spoke with Commissioner Kearns, about that, like you could not use the name of another, of a council member. And I don't remember what the final resolution to that discussion was they were having. It was,
Yeah.
I think it was earlier this year.
I can call Mike Piccolo.
It was something to that effect, though.
I mean, I think it's what I learned, I don't know, what I've, when I was doing my parliamentary procedures with the Jurassic Parliament. It's something that I think we talked about before, but to look into. I think your Second Amendment rights allow you to say anything, like you can't stop someone from using profanity even. So that they can say anything they want to say.
That's
Yeah.
what Commissioner Waldorf was alluding to. Once you allow this process, there are certain limitations on what you can tell people they
Yeah.
can say.
Because Scott and I were talking about this too. It's like,
The
because
city has struggled.
they shouldn't be able to
Yes.
talk about a specific employee, but I think they can talk about, since we're all elected, they can say our names as much as they want. And in whatever vein they want.
No, I know, that's why I'm saying, I don't know if we want to go down the path the city was looking at, and I don't even know if the city still has that, but I know at one point they tried to shut down any reference by name of, except for the council president, who you were addressing your remarks to, and I don't know if they still do that or not.
I'd be curious, because I think from a Second Amendment perspective,
Yeah,
what I
yeah.
heard was that they.
First
or
Amendment.
I mean, we support both here, but what we're discussing is the
The
first.
Second Amendment will solve
Three
the
of
First
us
Amendment issue.
support,
Yeah,
three of
you're
us
right.
support both.
Oh, yeah.
We have the
Yeah.
First
informal,
Amendment rights, sorry.
The second is there to protect the first, but I get what you meant.
we have the informal mic cutoff policy, also known as Rebecca.
Yeah, yeah, Rebecca.
Commissioner Jordan.
Does the valley have a time limit on the open public forum?
I'll find out, Commissioner. I don't know. I think they do. My understanding is very similar to ours.
Yeah.
3 minutes.
Yeah,
And
three
I think it's a
minutes.
15-minute total.
And can be extended by the chair or the
Right.
council president, mayor. Okay,
I'll check that.
be good to know.
Okay, so then we'll come back in a week, put that back on the agenda for a week, but I would just. Tomorrow just state that that's
Well, yeah.
discussions that we had, and it is your prerogative.
Mm-hmm.
And then the other thing was, at any ribbon cuttings or groundbreakings, I know there was one recently, but we just need to make sure that we invite all commissioners that are in attendance to come up for whatever the ribbon cutting or the groundbreaking is. But I would say too, that I don't think that Pat or, she's not here, Martha Lou, that we need to make sure that the communication, if they're the ones setting it up and doing all that, we've got to make sure that they know in advance who's all going to be there as commissioners. I know I haven't always done a good job of letting them know I'm not going to be there. So that's just on us to make sure we're fully aware of that.
Oh, is there an update? Speaking of,
Oh, yes.
is there an update
I-
on Bigelow Gulch?
We had a discussion, the guardrail people.
Yes.
So no, it's gonna be the end of the month. Yes, because they're not getting it, and just the timing of all their other jobs, based on what they had contracted with the contractor for, so. It'll be the end of the month, I think the 20th, I said The fifth, whatever, next Tuesday was not gonna work at all, because they're just getting, again, the materials, and based on their schedule and stuff, so they will for sure have it done by the end of the month.
So we could just keep it as a placeholder miscellaneous next week as well, just to update, see what the progress is and see if we're anywhere closer to setting a date.
I think we could probably talk to the general contractor again,
Good.
and I think the 29th, I think is that Tuesday.
I think that's what Martha Lou was
Yeah.
suggesting. Yeah.
I think we could talk to, are you out of town?
Oh,
When,
Pat,
I'll confirm with Martha Lou and with Kyle, but I think the 29th is what we were envisioning. If I'm hearing correctly, you know, the road might be open and ready for service ahead of our ribbon cutting. We don't want to delay that. Obviously, people have been anxious. So, but we have identified a good location. And so we'll report back. I can talk with Martha Lou about maybe coming in tomorrow if we have any updates under miscellaneous.
okay, I'm not sure that it really will be open because the subcontractor was thinking the 29th for guardrail would be probably closest they could get to it.
Got it. Sounds good.
to install the guardrails on the 29th?
Well, the material comes in
Yeah.
and so then they have the 15th through the 20.
Yeah.
They have 2 weeks to get it in.
Yes.
And they're scheduled out on other projects as well, so they're not thinking they're gonna be early on it.
Well, so you don't, but do you think the road will be open on the 29th?
I
Or are
think
we
so.
gonna be cutting a road for a road that's, or cutting a ribbon for a road that's not
I
open
think
for a
it'll be-
couple more
yes,
days?
It'll be open.
Okay, okay.
29th. They will
Okay.
have the guardrail in by the 29th, I guess.
Okay.
You just didn't wanna, don't make me do it sooner, Mary, so I got, so I can't commit to before.
Correct, all angry calls to Commissioner CUNY's office.
No, which was their time frame. So. Commissioner French.
so tomorrow morning, I'm giving welcoming comments to the Northeast Rail Summit conference that they're having here. So I figured maybe I would just share with all of you that I'm been asked to do the opening comments for them. And then 2 weeks out, I'm also doing the opening comments and small speaking section for the Washington State Fire Commissioners Association. So yeah, both of those are obviously here in town.
Good. Anything else? Oh, Pat.
I just wanted to report out from the press tour and availability we had last week. Thanks to Commissioner Waldriff and Chair CUNY for being there and for leading that. We did get some good press coverage, and I expect that we will get some more as some of the print reporters publish those stories. So stay tuned for that. But got good feedback from the reporters, the camera crews, that they felt like we were being open, transparent, allowing them to get in and see the functioning of the facility, and they appreciated the time and opportunity.
Okay, thank you. No, I think it went well. So I think they did what I saw on the news did a pretty good, job of reporting, what it was. So. Okay, anything else miscellaneous? And
Tomorrow.
tomorrow.
Yeah.
Okay.
Exec session.
Closed session labor.
Madam Chair, just to confirm if I could, the clerk and I are in the process of getting our public hearing notices for the budget. And so I think we're having a hearing on November 18th, the Monday. October 18th, man, no.
No, November
No,
18th. you're right.
November 18th.
That's
I've
when
set
I-
it for 9 o'clock because that's the day you're gonna be at
Awesome.
9. I want to be sure it's 9 o'clock, board members.
Right.
Okay, and then your budget hearing is the first Monday in December. I've likewise set that for 9 o'clock in the morning. I just want to confirm, Madam Chair, that that's the time you want to meet.
Yes.
Okay, thank you very much.
And there is no public forums at either of those because I think we've have finished our public forums.
The November 18th is a public hearing, Madam Chair, to consider increasing your revenue. Your public hearing on your budget is a public hearing to discuss the adoption of your budget the first Monday in November. That is a public hearing, Madam Chair.
Okay. Thank you.
Yeah. And then one further item,
Okay, just
pardon
a
me.
quick question on that, Jim. So are we adding any other items to those? Can we,
Yes, we
if we
are.
choose that we need to add some other board items, can we make that choice later or?
They're special meetings,
Got it.
so we have to advertise specifically what you're gonna act on.
Okay.
That doesn't mean you can't talk about anything, but no final action.
Got it.
I think Commissioner Waldrop's asking, can we have another meeting? Like we have on for our strategic planning meetings, can we schedule it for following the budget, the public hearing?
I was just saying, if we had more items, we had to
And we've done that.
fit in, because towards the end of the year, I know a lot of departments are trying to get us to approve contracts and adopt things, and so I was just
Right.
wondering, but you would have to just notice that as a different meeting.
That is
after
correct.
that meeting.
That's correct,
Okay.
Mr. Simmons, yes. And we can do that very easily as long as we have sufficient notice, 24 hours, Madam Chair. And of course, Commissioner CUNY can sign those special notice meetings.
Randy?
Okay, just, I hear somebody popping in up here. Hey, Randy,
Hey,
go for it.
just going to remind you, you also have a Tuesday meeting that week. So any of the other contracts and that could also go on the Tuesday meeting. It wouldn't have to be on the Monday.
Yeah, I wasn't thinking the 18th, I was just thinking
As we
on
move
the
forward.
first.
Yeah.
Cause we normally would have our strategic planning meeting.
Yeah.
No, we all wanna go to Wasac after that 18th meetings.
And thank you, Madam Chair, for indulging me. So I want to be sure the board also understands that when Randy and I prepared the potential increases in revenue from 2024 to 2025, we put in all the potential options. But the notice makes it very clear that we're just putting them all in. The board will determine on the November 18th hearing whether or not you're going to increase by 1% or not increase by 1%, whether or not you're going to do a shift or you're not going to do a shift. If you're going to shift, how much money you'd shift. So we have all the options in the notice, Madam Chair, but the notice says we just put them all in there to give you all the options at one time. And we did the same thing the last couple of years, Madam Chair. Yeah, it works very well, but I didn't want the board to be surprised when you see the notice of public hearing and someone may call you and say, well, why are you advertising a 1%? Well, we're advertising because we're putting in all the options for your consideration. Thank you, Madam Chair.
Thank you. Okay, and then, yes, so tomorrow we will have in the morning.
Yeah, in the morning.
Okay.
Yep.
So after our agenda in the morning, we will do should be done around 10:50, probably a 20-minute closed session on labor. So it's not an executive session, it's a closed session. So.
Yeah.
There we go.
We finally got that right, Madam Chair.
Make sure we got it right.
It's always-
How long did it take to get that?
Well, I think the board's always been aware of that, Madam Chair. We just kind of put it as an executive session to make it simpler,
Yes,
but no need.
technically.
Yes, but it's just,
Yes, it is not subject to the OPMA. That is correct.
it's basically like an executive session.
Yes, it is exactly right.
I don't know. Wording. It's all wording. So, so with that, just so everyone's aware, I don't think there's anything else on executive session for tomorrow.
I'm not aware of it.
Okay, I'm not either. So just so everyone's aware of that. And then I'll be here in most of the morning, and then I may have to leave and let Josh take over, and I'll be on Zoom. Okay. Thank you all very much. We will then end for today and see everybody tomorrow.